At IMX. My name is Tinko Georgiev. I'm Vice President of International Business at Kanjian Music. And today we have Petit from Backstage Legal to tell us more about copyrights and international practices for monetization of copyrights. Welcome, Sundar.
Yeah. Hello. Nice to see you online here. And thanks for inviting me.
Very much welcome. Would you like to tell us a bit more about yourself and Backstage Legal?
Yes, of course. So my name is Petit. I'm an entertainment attorney and I'm based in Amsterdam in the Netherlands. I'm also a guest lecturer at several universities, music colleges, and I write a lot about music law in several magazines. I've been a columnist, for example, at the DJ Mag Netherlands for a couple of years. I'm indeed the founder and managing partner of Backstage Legal. That's a creative law collective. So it's a collective for creative lawyers that each have a background and a lot of experience in the creative industry. Besides my job as a lawyer, I'm also a part-time DJ and I organize events. And I host a small techno record label with a couple of friends called Kelder Cluster Recordings. And most people in the Netherlands know me as the dance advocate, or translated in English, the dance lawyer. I have a big passion for electronic music, a lot of knowledge from that industry and sector, and I practice law and try to combine my hobby and my passion in that regard. So a little bit about some background about Backstage Legal and why I've started it. So I've started it this year to make a collective or a platform for independent lawyers that are also entrepreneurs. And I wanted to gather people from all aspects of the creative industry to work together to share knowledge and also to have a group of entrepreneurial friends around me. So, for example, we got a bassist and a music composer that's been playing a quite famous touring band, and he is still composing music for television series like Suits and Californication. He's a former member of collective rights organization and supervisory board, and so he got a lot of experience in that. He's also doing a tech and privacy law and employment law. We got a lawyer who owns an event production company and a podcast studio, and he's got a broad cultural experience in several boards. And we've got a rapper, stand-up comedian, radio host, and he's also a lawyer, also with a financial background. And I have experience as a former fashion label owner, and as I said, I still DJ and throw parties. And I'm an attorney specialized in intellectual property law, media, and contract law. So we work for everybody in media and entertainment sector. Personally, I've worked for DJ Mag Top 100 DJs, record labels, clubs, festivals, promoters, managers, booking agencies, models, photographers, TV personality, rappers, also an NFT platform since quite recently. Basically, everybody in media and entertainment.
Thank you. Very, very, very good. And I'm sure that many Chinese artists and labels would be interested in representation outside China. And by all means, they should get in touch with you via the IMX platform. And,
yeah, sure.
Talking about all of these, and it's quite a wide range of clientele that you're working with. Would you like to go through maybe an overview of the most common practices for monetizing copyrights? And of course, if you decide, and as it goes, we may decide to dig deeper in some of these bits and pieces.
Sure. Yeah. On the one hand, it is a broad variety of a clientele. On the other hand, if you look at the legal back end of it, so I have a master's in corporate law and intellectual property, and I also practice media law and contract law. So from that legal backend, we can service basically the entire industry, because one of the most important things for intellectual property rights, so copyright, neighboring rights, we'll get into that a little bit further in the interview, trade names, trademarks, etc., is that a transfer of those rights or an assignment or granting another person permission to do something with it, you need contracts for it. So the legal background to the practice is a translation that we'd like to make and that we can make because we have a lot of experience in the industry ourselves. And if we talk about the monetization of the copyrights, and with that I mean the copyright and the neighboring right, the overview could be quite the same. But let's take it for the music part in this regard. So if you look at the copyright protects something that is creative, that is original, that is not stolen, basically. And if you look at music, copyright is about the composition of a song, the text of a song. So it's basically the theory of music before it is sung, before it is performed, before it is recorded, with that neighboring right. Let's get back to the copyright. If you would fold a paper into double, you could, on the left-hand side, well, this is right for you, right? Left-hand side for you. And you could say copyright, composer, writer, and the party that's exploiting those rights professionally is usually a music publisher. If you look at collective rights organizations, that are the organizations that collect money, and you grant them permission to do it, and they grant the permission to everybody who uses your copyright, hence the collective part. That's also in the copyright part. In the Netherlands, that's called BUMA Stemra. BUMA is for public performance. Stemra is for mechanical reproduction. But that is the column that is about copyright. For each of those specific sectors, if you want to grant somebody else permission to do something with your copyright, you could ask money in return of that permission. And if you dive deeper into it, what is copyright, or what are the exact rights that you could get as an author or as a writer, I would advise just take a look at the law. It's not super difficult. Just find the article or Google how to find the article that says what are your rights. And then you will see that it is all connected to exploitation. Exploitation usually means public performance and reproduction. And reproduction could mean changing the work, so like rewriting it, making a remix, for example, or copying the work, and that's the mechanical reproduction part. And if you split out those rights, then we are talking about lending, then we are talking about broadcasting, then we are talking about promoting it, playing it, etc., or deciding whether your copyrighted text is performed and recorded, for example, on a master recording, on CD, blast tape, whatever. So that is copyright. Next to that, in most European legal systems, is neighboring rights. Neighboring rights protects the performance, like the creative performance by a dancer, by an artist, for example, by somebody who's playing piano or violin, but also if you're playing a 909, or if you're playing a 303 or a MIDI synthesizer. And it is protecting the investment of the record label. Well, record label is not really what is in the law, but it says phonogram producer, and phonogram producer is the party who takes the initiative, the lead for financial risk and or financial risk, for example, in taking a record, for making a recording. And same for copyright and neighboring rights, you can decide upon the exploitation of the recording and your performance, meaning you can distribute it, you can decide if you want to let others perform it, if public performance is allowed, and there's also a system of collective rights and collective rights management to the neighboring rights part. In the US, neighboring rights are called sound recording copyrights. So not to make it too difficult, but what you need to remember is that copyright and neighboring rights are two different rights, possibly for two different persons. And if you have that right, you can exclusively decide upon what you want to do with those rights. And because that is exclusive, you can grant other people permission to do that in your name, for example. And for that permission, you can get money. That is the monetization in its core. Just to give you a small oversight of what are the possibilities and what I've just been talking about, I want to share my screen for a second to just see it here. So on the left side, if you're an author, you're making a musical composition. So it could be a project file, but back in the days, they would write it on a paper, for lyrics, you get a copyright. If you're a performing artist and you are, for example, singing the text, you get a neighboring right. You are a phonogram producer, you are recording sound for the first time with the goal of commercial exploitation, you get a neighboring right. If you are a DJ, and here I mean live DJ, you could be playing on live instruments and remixing while you are playing. You could also get a neighboring right for that performance. And if you press record either on your device or a recording device, then you will also be the person who is getting the neighboring right. This is an interesting overview in this regard. Just see what you do, what it creates, and what rights is linked to it. About the monetization part, I want to dive a little bit deeper in the royalties, because the royalties are the reimbursements, usually on percentage based, but it can also be on a flat fee that is connected to that permission. And here on the left-hand side, or of the left of the right, the red line, is the system of collective rights management. There you see the Dutch companies, but please look up what are in your country the collective rights organizations, assuming that people from all over the world will be watching. BUMA is for the public performance of copyright, meaning that if you have a club or a festival, you have to pay a license to BUMA or to your public copyright organization for the performance of public performance of copyright. The same goes for SENA, that is like the counterpart but a neighboring right. So copyright is the text and composition, neighboring rights is the performance and recording. STEMRA is the party in the Netherlands that goes for the mechanical reproduction. So if you make, for example, 1,000 CDs, you will have to pay a license fee to STEMRA. STEMRA will pay the license fee to the authors and composers that are members of that organization. Norma is the party for TV, so there are also TV rights, and those like the television stations have to pay a license to Norma, and Norma is paying the license fees to their members. On the right-hand side of the red line, you will see the more common royalties, sales, iTunes sales, Apple Music, Beatport, physical sales. There are flat fees, and what is missing in this oversight, well, in the monetization part maybe, is also licenses. And we'll get into licenses and the difference between licenses and transfer of rights just in a bit. So just to round up, the most common practices if you talk about monetization is what permission can you grant to your rights and what money can you get for it. And as I mentioned, the professional parties exploiting your rights will basically be a music publisher exploiting your copyright and a record label exploiting your performance and the recording thereof. And they try to make deals about it, basically. They try to promote it, getting it into Spotify playlists, getting it heard at promoters and booking agencies, get you deals. But what's also very interesting in this regard is music synchronization. And synchronization is seen, at least in the Netherlands, it's seen as alteration or reproduction of the copyright combined with video and audio. So that is a new form which you can grant permission for. It's a right because somebody's changing your copyright and they need your music connected to the video. Hence, you can ask money for it. And with our online society, digital society, and a lot of brands, for example, using music in small video clips and social media, and also in films, for example, this could be really beneficial for your practice as a creator. And last but not least, I think really something, but we'll dive into that in I think a little bit about what the future brings us. I think the NFT platforms and the possibilities of, the crypto world and the artwork together is also very interesting in regard of monetization of copyrights, but that's still a field that is under a lot of, I think, pressure and hype, but it has great potential to get a fan-artist connection or author connection, but also in regard to monetization, especially now when in most countries there are still some limitations on Corona in regard of public performance parties, etc.
Very interesting indeed, and thanks for the straightforward explanation about all these underlying legal concepts when it comes to, you know, people talking. And I pardon my point here, but people usually talk about streaming and downloads when actually everything that lies underneath that is the legal practices. And that's why I'm excited about having this conversation with you today, because I really wanted to highlight these so for the wider audience to really understand the mechanics of what goes behind I think
it is indeed very important, because this is the practice. So something gets sold, but then the chain of rights makes it interesting to see where that right comes from. And I think it's very, very important to note this, not only because a protection of your rights, but also if you want to progress a career in the music industry, then you need to be aware of your rights, because being aware makes you see the different streams and possibilities of gaining income. And if you see it and you know your rights, if you know where the rights are and where the money is, then you can make smart deals about it. You know, if you see, and if you make smart deals, then you can get more income, and more income will lead to more freedom, and more freedom itself will lead to more creativity, which will lead to more work. And you get into kind of like a positive spiral upwards. Not saying that the music industry or the creative industry should be about the money, but I think if you want to build a sustainable career and keep doing what you really love, that the business aspect, and in this case, the legal aspect, is a very key element, like a key element in progressing and getting better and growing as an artist. And yeah, that's why I think it's very important. I'm glad to talk about this here and explain a little bit to you how the system works.
Yes, I'm a big advocate of bringing the scientific approach to the music industry, and I know lots of companies are doing this. Just wanted to underline and highlight how the importance of the mechanics between getting a track on iTunes with the underlying composition, generating revenue through that, and how that revenue is being generated exactly is the key point of this conversation. And you mentioned earlier in the conversation about the difference between licensing and transferring of rights, or assigning of rights, as it's also known. Would you like to elaborate on that?
Yeah, I think this is an important aspect of granting that permission. There are, in my opinion, 3 ways to do it. One is a non-exclusive license, one is an exclusive license, and there is a transfer. Transferring basically happens when you buy something in a store. So if you buy a telephone in a store, you pay money, you get the telephone, it's your telephone. A license works a little bit different. It works like you go to a store, you pay for a telephone, you can use the telephone, but it's not yours. It will still be the telephone of the telephone company or the store where you bought it. So you just pay to use it, but it's not your property. And the difference between the exclusive license and the non-exclusive license is, well, of course, that exclusive means that you grant the right to another party, and that other party will be the sole party that can do something with it. But if you look at it from at least our legal perspective, a transfer of copyright or neighboring rights or whatever, and an exclusive license, you need a contract for it. That is the reason why there are so many contracts in the creative industry, because most laws require a written and signed contract to transfer or exclusively license those rights. A non-exclusive license is, at least in the Netherlands and European countries, is form-free. So we could do it on a beer coaster, we could do it via WhatsApp or via chat service like WeChat. And so it's less formal, but it's always explained very limited. So what is not in the transfer, what is not in the license, is not deemed to be given away to the other party. So that is also why you need people that really dive deep into those licenses and see and explain you, either as an artist or a professional party exploiting those rights, what are you exactly getting? Because if it's not in it, you won't get it. And this is something really relevant for a lot of the famous DJs from the Netherlands that really helped taking off the electronic music industry worldwide, is that they signed contracts in like the 90s, but there was no iPod yet. There was no digital exploitation yet. So that part is not in those contracts. And now when the contracts sometimes end, after 30 years or I don't know what term, the contract ends, or they want to prolong the contract. And most of those artists will say, well, but now we need to make different arrangements because those electronic and digital rights are not included in the initial contract. So if it's not there, you won't get it. And the difference between a transfer and a license is that with a transfer, you really transfer the ownership of your rights to another party. And with a license, you just grant permission to use it. Well, transferring those rights or signing those rights is like the furthest you can go. So usually you will get the most money or other terms back for it. But the more you give, the more you get. And in reverse, if you're the professional party exploiting those rights, if you want all the rights, you will have to pay a little bit more than if you just get an exclusive license. Also, because an exclusive license is a contract. There is no transfer of property. But if you look at a property law effect, like the theoretical things behind when this property transfer, I won't dive into that very deep, but you need an extra action to retransfer those rights. Again, you need an extra contract. And with a license, you could basically just terminate the license and you will get then the permission ends. So, yeah, transfer is a little bit more than a license is.
Thank you. And if I may follow up on this, and of course, if we try and play devil's advocate and work on both sides, artists, creators, and artists on one side and publishers, record labels on the other side. In what cases do you think artists would prefer to have a license rather than a transfer? Sorry, let me reword this. In what cases it's more advisable for an artist to do a license, and in what cases to do a transfer, and vice versa for labels? Just very briefly to give a practical idea of how this theory works.
I think for artists, a license is usually better. With a license, you can place the party who you're giving a license to in the exact same position as you would have transferred your rights. But the license is a contract which you can quite easily or more easily terminate. And then you do not have to retransfer rights. And again, you have a little bit more control over your rights, and licenses, well, can be for shorter term, so it's a bit more flexible. Of course, it depends what is exactly written down in the license. For a company, it can be beneficial to actually have the rights if you work together with third parties, and the third parties ask you to give a guarantee that you are the owner of the rights, then you will need to transfer. Then a license or an exclusive, non-exclusive or an exclusive license might not be enough, take into consideration that the artist could terminate the contract, and that will leave you without the rights, and that will cause a problem for you if you granted a guarantee to a third party. So for companies, and also if you want to sell your company, then usually having the ownership instead of having risk-bearing contracts is good for the valuation of your company. That might be a difference and a reason to assign a transfer right instead of just having licenses. And even though there is this technical difference in the end, it all comes down to what's written down in the contract anyway. But that could be, an answer to your question in that regard. I hope.
And just as a side note, in this conversation, we're talking about artists, where artists are the rights holders, or versus commissioned work, where somebody works in for a company and or they are commissioned, in which case probably and very likely the rights will belong and will be owned by the entity commissioning the work. Just wanted to add this as a side note, and if you want to add something to that as well.
It is possible, but please check the rules of the collective rights organizations, because they usually have a clause in it that says that if you work for an employer, for example, that you will need to have certain stipulations in your employment contract, still saying that you will be the owner and the maker of those rights. So even though if you transfer those rights, or if the rights are commissioned by somebody else, you really need to see how they are commissioned and how the system works and how the rules of collective rights management work, because they could, have some specifications. If you were in such a situation, please ask an employment lawyer or an intellectual property lawyer with an employment law background if there are any specifics to take into account when you're signing a contract or signing with a collective rights organization. Commissioned work, yes. If somebody pays you to write a song, that would be commissioned work. I know in the US there is work for hire construction, meaning that the rights are automatically from the company that is commissioning you the work. But in the European countries, that is quite different. If somebody is really telling you exactly what to do and you're only doing that, so if somebody that is like a master painter, like Rembrandt, he had a lot of students doing exactly what he said, but they were still creating it. But because he was having the lead, he would still be the copyright owner. But for example, if you are a music producer and you're producing for an artist who's giving you an assignment to do it, that does not mean that the artist will automatically have your rights, because you will still need to transfer them or exclusively license them by form of a contract. If it's not in the contract, it's not transferred.
Very good. Thank you indeed. And just to get back again on something you mentioned earlier, you talked about some of the Dutch DJs who signed contracts in the 90s. What about some of them that signed contracts now? I mean, what is a legal talk without talking about any particular cases? And I'm sure there's some cases that are making headlines now. Would you like to
definitely
talk about some of these?
I can talk about it, as I was not involved as an attorney in this, but I think the most famous court case that we are all looking forward to is the court case of Martin Garrix versus Spinning Record label and his former management company, Music All Star Management. So we are expecting a verdict from our Supreme Court in the beginning of October. And this will also have consequences for music rights, especially neighboring rights, and how we look at contracts in the Netherlands, but also possibly in Europe. And with that, it has effect all over the world, especially as a lot of Dutch companies and Dutch artists are working together with everybody all over the world. And we're quite good at what we do. So the Martin Garrix case is about two things. I think for one, it is about conflict of interest in signing deals and when they can be nullified or entire void. But the most important part from an intellectual property point of view is who is the phonogram producer. In other words, who owns the master rights. And as I said before, connected to those rights, there are a lot of income streams, and connected to those income streams are a lot of deals. So there's a lot of money involved, especially for a big DJ like Martin Garrix, because this is about the big hits of the beginning of his career, his evergreen, so to say. And the court case is diving really deep into the law. It's so, international copyright treaties, and how they trickle down into national law. And they have a discussion, how the process goes. in signing a record deal and who owns the rights. So what happened is that Martin Garrix was thinking about music, laying in his bed at his parents' house, for example, and creating the music by copyright. So he was thinking about it, and then he was performing it in his own studio, and he was recording it. So he got neighboring rights. And he was paying for vocalists and for the mixing and mastering, etc. And based on his record deal, he had to offer the track to Spinnin' Records. And Spinnin' Records had the possibility to say, we don't like it, we're not going to release it, and it's not in your release or delivery requirements and commitments. So then all the risk of creating the track and paying for the track or investing in it would be with Martin Garrix. But also in the contract was stated that Spinnin' Records would be the master owner. So that is kind of seen right now as a hypothetical situation. So there is the situation, what happens if you look at the law, Martin Garrix record master owner, and if you look at the contract, it's Spinnin' Records master owner. Spinnin' Records said, well, we do all the promotion, we do the A&R, we did the mastering, we made different versions of the track, like a radio edit, etc. We can commission remixes. So, and the raw music went through their studio boards, and that was recorded into the final version that was released. And now it's a discussion, who's the master owner? Because connected to the master ownership is a large part of the sales and is a large part of the collective rights income. As I mentioned before, in the Netherlands, SENA is the party who is the collective rights organization for neighboring rights, so for performing artists and record labels. And what they get in, they split 50-50. So there is 50% of that income is for the artist and 50% for the phonogram producer or the record label. You can imagine with Martin Garrix, 50% of an income is quite a lot. And if he is to be seen as the records owner, like the master owner and the phonogram producer, actually in this case, then he could claim the 50% of what Spinnin' Records would have gotten. Well, has got now. So we're talking about millions. And this is important because the way Martin Garrix used to work and the record labels used to work is very common in the music industry. There are a lot of bedroom producers, or the guys and girls who spend all their savings on the studio and they have extra jobs, to pay for extra equipment, and the record labels claiming the rights. And we will have to see this in a broader perspective of the changing role of record labels and music publishers in a digital era. Back in the days, and that's why the law is basically also created, is that if you wanted to make a track as a band, you needed a huge studio with managers, with producers, with, if you see the old pictures with all the little knobs and things, and if you want to buy effect, that would cost you tens of thousands of dollars. And now you can buy a plugin online. So to get back that investment, and the idea behind the law is gradually shifting. And the tasks of a record label are gradually shifting. And they are more about fine-tuning sometimes and editing, but not so much about the basic creation and the recording of the sound, because that lays with the producers themselves usually. And the discussion now is if a change of sound happens while making those versions and what Spinnin' Records actually did, if that could still constitute a right to a phonogram producer within having master ownership. So that's why this case is super important for the music industry, not only for electronic dance music and hip hop, which is also another pop that's also made in studios with electronic gear, but all over the industry, because it might totally disrupt the way that the income streams on the neighboring rights sides go. It's an interesting court case, and what makes it extra complicated, by the way, in this regard, is that Spinnin' Records, so the record label and the management company, are from the same owner, or were from the same owner. And as a manager, he needed to advise the artist to sign a good record deal, but that would be a conflict of interest. So it's a nice triangle and a nice story. And hopefully somewhere at the beginning of October, the verdict is there. And I think during Amsterdam Dance event, there will be large discussions about this, because that is, I think, the first big conference after that verdict. But we are all looking forward to what's going on there. You know, it's like, it feels a little bit like David versus Goliath, and taking the practical side of the music industry and contracts and what the law says into consideration. So yeah, it's exciting for us.
Very much. I think it's exciting for everyone who's got, first of all, vested interest in that, and of course, I don't mean on the side of either of these two parties, but in general, that has a stake in the outcome of this court case. But also anyone who's more interested on the legal side of things, with the business impact and the business impact of those legal aspects.
Yeah. So if somebody else, by the way, wants to dive deeper into it, I've written a really extensive article about this court case on my website. And on the right side of the page, there is a translate button. So you can translate the text in any language you want, from Swahili to Chinese to Japanese, anything. So you can get a broad overview of the case. And there are some pointers for you as a record label, as a manager, and as an artist, what you could do with the takeaways. And
what's the website? I think it's going to be
run is
with
www.danceadvocaat.nl, but maybe it's a good idea to put it in the show notes, or you can find it on my profile.
Yes, very much indeed. Thank you. And talking about cases and how this is shaping the industry at the moment, what do you think about next 3 to 5 years? And of course, if you want to talk about further down the line, what do you think the future holds? And is like really an open question?
I think a couple of things are important. The copyright reforms for in Europe. So there are several copyright reforms that are trying to make the industry more balanced and more fair to creators who have historically have a little bit more dependent and weak position in regard of the people who are exploiting their rights. And they're trying to bring that closer together. I think that is a very good move, because if the level playing field is more equal, if you have a level playing field, then the dependency is kind of, you know, more natural. It has a more natural relationship towards each other. And I think that the relationship between those parties will create a situation where artists and authors, etc., and creatives are more fairly reimbursed for their work. Hence, they will get more money, they will have more freedom, they will create better stuff. And they try to close the value gap, meaning that big platforms like YouTube and Facebook will have to pay up for the intellectual property rights that are on their platforms, especially copyrights. So that's kind of something that is enrolled right now. And we will have to see the implication in like now to 3 years. Something else, I think, what is very interesting is the recent hype on NFTs and the possibilities of that. So just a little bit of background also on an NFT. It stands for non-fungible token. It's basically a digital certificate of ownership. Could be digital art, could be on music, and you get the ownership on, could be on a copy, so on an MP3 file. And that is the ownership is put into a blockchain ledger. So on a blockchain, then every time a block comes on top of the chain, creating the blockchain and carrying all that data inside who owns what. It is fairly difficult to declare why the hype boomed quite recently and why the artwork as an NFT are sold for such an insane amount. But it is an interesting way in actually monetizing something that was not scarce. You know, if you go to a record label shop and there are only 100 records, like vinyls worldwide pressed of the Weeknd track, and they will be sold for insane amounts. I don't know if you can remember, Wu-Tang Clan released, I think, one LP and one vinyl a couple of years ago, and it was sold for like millions. Same goes kind of with the NFT. So they are creating scarcity in a digital platform, in a digital world. Most easy way to understand this is if you play an online game and you can own a piece of land and the other players can walk over that land. And I can say, hey, I can understand that because it's digital, you can own it. And it kind of works like in the default in our world. If you buy land and you get proof that you have it and it's your property. What still puzzles me sometimes is that what you have what NFT is linked, like the artwork's linked to the NFT, that it's public, could be public to anyone. So why own a digital copy of it? It's still unclear to me sometimes, but I do understand that, the system behind it, but it's kind of like ration connected to emotion. It's a little bit different. But the NFTs are created on the NFT platforms as collectibles, for example. People pay good money for it, usually in crypto, Ethereum. And I think that will progress kind of in the coming years. So besides the financial or speculative possibilities of trading in NFTs, I think it is also a very good way to reconnect the artist with the fan, given that we are so digital right now. And if you look at DJ Don Diablo, for example, he launched an NFT, meaning minting, meaning creating one, dropping it, meaning making it public. So he dropped an NFT and sold it for a lot of money, but with the NFT to his music was connected a hologram with his first music controller in it. And if you are one of his super fans, then it's interesting to not only buy his music, but buy this unique piece of art that created and really meant something to him, and I can imagine that those kind of possibilities with NFT, like bringing back digital worlds with the physical world, are very interesting. But you could also connect, I don't know, like VIP tickets to your shows if you buy the NFT of an album. You could have special experiences, like 3D experiences on your TV that no one else had, or see a concert that no one else has access to. So there are a lot of new possibilities to make the purchase of digital stuff more interesting. So it's not, you can, like have some extras with it.
That's very good and very good overview. I'm sure we can do a whole session on NFTs and the business and legal aspects of NFTs. And but I guess it's a very interesting topic, definitely trending at the moment. But if you were to considering we've got a lot of professionals and artists both participating and watching IMX, going forward, if specifically the artists, if they need to learn more about one particular aspect, and I know this may sound a bit silly, but if they need to learn about one particular aspect of the legal system, where do you think they should, in terms of growing their business or protecting their rights, what do you think is the best point to start with, if they need to understand this on their own, rather than getting a third party to look after their rights?
I think it starts with your internet search engine. It could be Google, wherever you are, what's available. You just try to find some terms that are relevant for you, just where you want to go, and then you can get a broad overview. From that broad overview, if you want to dive deeper into the music industry, I always recommend Donald Passman's book. It's called All You Need to Know About the Music Industry. I don't have any stake in him in the book, or I don't know Donald personally, but I think it is written to U.S. law, but it gives a fun to read, easy to understand oversight of the music industry. So it's not like a difficult academical stuff but it's really practical with examples, sometimes even pictures, how things go. Like if you put $1 in on top and it trickles down, what do you have at the end? What do you receive? I think that is a very interesting and important source of information how the music industry works. There are some really interesting online courses from several universities around the world who have courses about copyright and even about music copyright. So it's the same if you want to learn more about your new music equipment, you watch a tutorial. There are also tutorials about the contracts and rights in the music industry. I think that is very important. And there are a lot of companies like Songtrust that have really extensive guides on how publishing, for example, works. There are other platforms that share a lot of good knowledge about it. But I think those are the steps to go. So get a broad overview, then read a good book that really contains all the information. And then if you read the specific blogs or guides or white papers from companies that are specialized in one of those aspects, then you will be able to place the other two sources of information very well. And I think that is a very important step to be either become a music industry professional or to get a more broad overview of the music industry. Because I said in the beginning of our talk, as soon as you are aware of the rights, then you can identify the income streams connected to it. And then you can make smart deals. And I think that's beneficial for if you're an artist, but also if you're a company working in the music industry.
Absolutely. And I would add also Anne Harrison, Music the Business.
Yes, that's a good book.
Yeah,
it's a little bit more in depth, you know.
Indeed,
it is a little bit more in depth than Donald Passman. So if you finish Donald Passman and you like reading, definitely get Anne Harrison's, because she's also talking about percentages a little bit more than Donald does, and it goes a little bit in deeper, and it's specialized to the music case. It's written from UK law, so that's something that should be taken into aspect, which is very interesting, as the United Kingdom left the European Union, but still it's a very good book to read. And yeah, if you have specific questions in that regard or how things work here, or you need a more in-depth review, you can always shoot me an email.
Absolutely. Thanks, really. And just a few final words. You've got the audience, China, the rest of the world. If you want to say anything to our viewers and participants at IMX this year.
Sure, well, thanks. First of all, thanks for listening and watching this. What I have experienced as a DJ and a promoter and an attorney is that it's most important to create stuff from the heart. But you need to think with your head and you need to follow your gut. And if that Holy Trinity is connected to each other, hopefully this talk helps you to grow on that part, and you make cool music from the heart, and hopefully we are all able to experience that. If you have everything connected, then I think I wish you a very successful career and progression in the music industry. And I hope to hear your stuff soon.
Well, ladies and gentlemen, thank you for watching. From me, Tinko, Georgiev, Kanjian Music, and Zonda Petit, Backstage Legal. 谢谢大家。
谢谢。
拜拜。
Bye.